So we just got some really big news out of the Supreme Court. Today on the Supreme Court order list, we found out that the Supreme Court is granting review to the next big Second Amendment case. And once again, this is going to deal with states banning concealed carry, putting in place concealed carry restrictions, and all of these laws that were passed on concealed carry, which were in direct defiance to what the Supreme Court already said in their 6-3 ruling in New York State Rifle and Pistol Association versus Bruen. So this is great news, it's big news, so let's talk about what just happened. Now, before we jump into this video, I know if you guys are concerned about concealed carry or you conceal carry often, obviously self-defense is a big priority for you. And I wanted to mention one of our main sponsors and supporters of the channel, which is Attorneys on Retainer. When it comes to protecting yourself after a self-defense incident, AOR is in a league of their own. In my opinion, they're the best on the marketplace. AOR is backed by an actual law firm, so they can help you in a lot of self-defense situations that other companies cannot. And one of the really cool things is they're constantly expanding their benefits, so you can get things like civil liability coverage, red flag law coverage, expungement, and a lot of other things. So again, check them out using the links down below in the details section, also in the pinned comment. And if you use my code ARMEDSCHOLAR, you can get $50 off of your individual plan or $25 off of a family plan. Now, as I mentioned in the intro, in this video, we have a really big update coming directly from the Supreme Court. Today, the Supreme Court granted review to the next big Second Amendment case, and this again deals with concealed carry restrictions in a case called Wohlford versus Lopez. This is huge for everyone in states like New York, California, Hawaii, and others who are currently facing and essentially living under these types of laws, which are attempts to ban concealed carry even after the Supreme Court issued the Bruen ruling. The Hawaii Wohlford versus Lopez case sought emergency Supreme Court intervention, which surprisingly was granted by the Supreme Court. This challenge revolves around a preliminary injunction and the Ninth Circuit finding that states can put in place these catch-all public property bans, and that would be permissible under the Second Amendment and what the Supreme Court said in Bruen. Recently, to the surprise of many, the DOJ and AG Bondi also stepped up in this case, and they supported this challenge, essentially trying to strike down this law that was put in place in Hawaii. They argued that it violated the Second Amendment. Well, that appears to have absolutely paid off. The Supreme Court, in a very surprising turn of events, decided to grant emergency review to this case. This grant of Supreme Court cert kind of breaks the track record of the Supreme Court, which prior, they had a clear track record of turning away all of these interlocutory cases, but this one they granted review to. However, I will say that this case was a little bit unique because of some of the things that developed at the lower court level and some of the arguments that were made to the Supreme Court in the cert petition. Now, if you're not aware, this case is a challenge to Hawaii's new laws on concealed carry that were passed in direct response to what the Supreme Court said in Bruen. This law, like others in other states, essentially tried to add more restrictions to concealed carry and create a default rule where individuals can carry firearms on private property only if the owner of that private property that's potentially open to the public, if that individual, that owner, gives you express permission. This law made concealed carry even worse than what existed prior to Bruen, and so that was challenged by the plaintiffs along with 2A organizations. They sued the state of Hawaii in federal courts, and they sought to strike down this law. Now, on review, a district court issued a temporary restraining order, also known as a TRO, against this law, and that was later converted to a preliminary injunction. Now, in that ruling, the district court blocked the private property rule, this kind of catch-all property rule, as likely a violation of the Second Amendment, and they said it was inconsistent with Bruen. The court determined that history did not support Hawaii's inversion of these traditional presumptions that you can carry a firearm at all locations unless the property owner says otherwise. This case eventually made its way to the Ninth Circuit along with the California concealed carry ban case, and on review, the Ninth Circuit upheld this catch-all property ban in the state of Hawaii, and they reversed the injunction that was issued by the district court. And after that, the plaintiffs essentially asked for the Ninth Circuit en banc panel to review that ruling of the lower court in the Ninth Circuit, but that was denied. And that led this case to then go to the Supreme Court on an emergency basis, seeking a reversal of that preliminary injunction. So again, this was still an interlocutory case. Now, this case, like I mentioned, had a hard road to get Supreme Court review since it's still at that preliminary injunction stage, and the Supreme Court historically has denied review to most of these types of cases. However, with the United States support in this cert request, the Supreme Court kind of broke that tradition and decided to grant review to this case. That is likely also because of some of the concessions that were made by the state of Hawaii at the lower court levels, at the Ninth Circuit level, and also because of a trap that was kind of set by the plaintiffs in the United States government. And essentially, Hawaii had no valid argument to seek a denial of this review. For example, in the recent amicus brief filed by the United States government, they stated that the near complete ban is flatly inconsistent with Bruin and the long history underlying it. Bruin recognized that an ordinary, law-abiding citizen has a general right to publicly carry arms for self-defense. One of the interesting things about this in the brief of the Trump administration is they also pushed for the Supreme Court to grant review to this case right here and now, despite the fact that it dealt with a preliminary injunction. And they pointed out that Hawaii in the Ninth Circuit argued and agreed that there was nothing else for the lower court to develop at trial and no further evidence was needed to be developed at the lower court level. This was likely critical to break through the Hawaii argument that this petition should be denied and kicked down for further review because Hawaii had already conceded at the Ninth Circuit level that none of that was needed. Now, in this cert petition and in response to it, Hawaii kind of responded with these same anti-gun arguments and statements that we've seen all of these states push, prior. They argued that this should be kicked back down to the lower court for further development. And they also argued that there was no circuit split at this time and there needed to be a final determination on this case. However, like I mentioned, Hawaii in that response contradicted what they already argued at the Ninth Circuit level. This was pointed out by both sides, by both briefs of the Wolford plaintiffs in the United States, and both sides pointed out that at the Ninth Circuit level, Hawaii said that nothing else needed to be developed, no lower court review was needed, and in fact, the attorney for the state of Hawaii made an express statement to one of the judges on the Ninth Circuit that they thought this was just a pure Second Amendment question and nothing else was needed. Also, when it came to the whole circuit split question, the Wolford plaintiffs recently submitted a supplemental brief also identifying a recent ruling out of the Third Circuit, which contradicts what the Ninth Circuit ruled on in this case. This further established that there was in fact a circuit split already on this issue that needs to be resolved by the Supreme Court. And the Supreme Court appears to agree, and they did agree by granting review to this case. This case went to conference this Monday, and today we got an order list, and on that order list, there was a grant of review to this case. That stated that petition is granted, limited to question 1 presented by the petition. So important for this review in the Supreme Court is the question 1 presented by the cert petition. So let's look at what that question is and what is the question that the Supreme Court is going to address in this case. That question is whether the Ninth Circuit erred in holding in direct conflict with the Second Circuit that Hawaii may presumptively prohibit the carry of handguns by licensed concealed carry permit holders on private property open to the public unless the property owner affirmatively gives express permission to the handgun carrier. That means that the Supreme Court will directly address the whole catch-all property bans that were passed in defiance to what the Supreme Court said in Bruin. It also is very likely that this decision and this upcoming ruling of the Supreme Court will dig deeper into the prior Bruin holding and outline a little bit more, develop a little bit more some of the things that need to be looked at on this type of analysis, and also address some of the things that have developed in the lower courts after the Bruin ruling. The Supreme Court will also have an opportunity to once again reiterate how the lower courts are supposed to perform this whole Second Amendment analysis when it comes to concealed carry issues, but also just generally Second Amendment cases. So we're going to get further analysis and further application of the Bruin analysis, the whole text, history, and tradition analysis, and the Supreme Court is going to perform that analysis once again on this case, and that will give further, guidance in clearer analysis for these lower courts. Now, will these lower courts follow it? We'll have to see, and it'll also depend on how firm this language is from the Supreme Court dealing with some of the defiance that has developed. But the Supreme Court will once again get to perform that Second Amendment analysis. So this term, the Supreme Court will once again hear a critical Second Amendment case, and they're going to rule on this once again this term. So with the help of the Trump administration, the Hawaii concealed carry ban case is now heading for Supreme Court review. This is great news and big news for the Second Amendment movement, so please spread this video around, spread this information around, and as we get more information, as it develops more, I will let you guys know. So if you like this video and you'd like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel, like, comment, subscribe, all of that. All of that helps to fuel Al Gore's rhythm, as we used to say. And also you can check out my website, armedscholar.com. Over there, we have a lot for you guys as well. But as always, thank you all for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.